Good morning, everyone. My name is Yuval Shani. I'm very happy. I'm chair of the organizing committee for this conference and also a member of the faculty and a long-standing researcher in Minerva. And I'm very pleased to open our 17th annual conference in international humanitarian law. This year we will be focusing on the war against Ukraine and IHL. I'm very pleased to invite the Dean of the Law School, Professor Tomer Brody, to say a few words in order to commence this part of the program.
Thank you, Yuval. As far as I'm concerned, you're still the Dean of the Law School. We have a sort of rotation system, so I've also been active at the Minerva Center for many years. I actually have to be in the other campus at the moment, but I wouldn't miss at least the opening of the 17th IHL conference, which is indeed one of the initiatives that Yuval launched a long time ago. We know how long ago exactly, right? It's 18 years ago. In any case, it is to some extent with mixed feelings that I greet you. On one hand, it is of course a pleasure to open what is by now a fixture tradition in the Minerva Center at the Faculty of Law. And in the international humanitarian law community. And I think that 18 years ago we couldn't have used that term. It was just a handful of people, in Israel at least, who are familiar with the field. So greetings, and it's great also. I think this is last year was still online, right? It was still via Zoom, so even though there are germs in the air and some people have had to call in sick, it's great to open a conference in the physical world. On the other hand, even the title of the conference is chilling to the extent that I think that maybe a year or 2 years ago it would have been I won't say inconceivable, because the war against Ukraine is not something new, and of course we have the 2014 invasion, and this is just over the last year or so an iteration of a phenomenon that does go back, in fact, decades. In the bloodlands, as the historian Timothy Snyder called the region, well, the bloodlands are once again, though the analogy is far from perfect, given the clear aggression on one side, the war against Ukraine and not the war in Ukraine. That is something that is not by chance a choice of the conference committee in the definition. If I want to add a lighter comment, then absent an Oxford comma, it's also the war against IHL. If you look at the title, the war against Ukraine and IHL. So it's Ukraine and IHL, but nevertheless, there also there's an erosion of the meaning of international humanitarian law where there are such blatant violations. So I'd just like to wish you 2 productive days, hopefully with meaning in the legal as well as in the real worlds. And as a precaution, nevertheless, to quote Timothy Snyder, when meaning is drawn from killing, the risk is that more killing would bring more meaning. So I think all international lawyers have to be also aware of the limits of international humanitarian law in its capacity to restrict killing. In any case, I'd also like to thank Yuval for fervently organizing, even from afar, in London. Einat, the current academic director of the Minerva Center, Dani, executive director of the Minerva Center, Anat, over there, and many of you, of course, know her, and everyone else has been involved, and of course the conference committee for their contributions, and for all of you for being here. So many thanks, and have a good conference.
Thank you very much, Professor Brody, Dean Brody. I now call on Dr. Einat Albin, who serves as the academic director of the Minerva Center for Human Rights, to say a few words on behalf of the Center.
So good morning, everyone, and it's wonderful to see you again and to greet you. Welcome to Jerusalem, and welcome to Mount Scopus and to this very interesting 2-day conference on the war against Ukraine and IHL. This is, as Tomer said, the 17th annual International Conference on International Humanitarian Law, initiated, led by Yuval Shani and Danny Evron for the past 17 years. And this conference has become a highlight event of the center, of the Minerva Center for Human Rights, a well-known and appreciated academic gathering in the field of IHL, which actually put the topic on the table for many people within Israel, regarding also the Israeli-Palestinian conflict, and of course around the world. This has become a central venue through which various different dimensions relating to humanitarian law have been explored in the past, discussed, analyzed, published, and developed throughout the years. And we at the Minerva Center for Human Rights, the leading academic institution in Israel on human rights, are very proud of the conference and are grateful to all of you for coming here and contributing to its success. Of course, this year's topic is extremely timely, important, interesting, and frustrating, may I add, as Tomer said. The war on Ukraine, which began this February 2022 at the central of Europe, reminds us that at any given time, massive hurts and destructions can occur, and that IHL, unfortunately, even though is still very relevant, deserves thought and consideration. But that even if we have such an important body of laws, mass suffering can occur, and the law is extremely limited in its ability to address it and provide aid to humans in such suffering situations. During the months of the war, civilians have been and continue to be injured and killed at alarming numbers. Critical infrastructures like hospitals, health centers, bridges have been destroyed. Millions of people have been displaced, with some making it to Poland, the European Union, while others trying to find safety in other areas of Ukraine. There have been sexual assaults and aggressions, prisoners of wars on both sides, in Russia as well as in Ukraine, of course, starvation, hunger, and the war also reached various international courts, the ICJ, the European Court of Human Rights, but it ended with no significant aid from the law. In the end, it can generally be said that international humanitarian laws are disregarded, something that is also evident in other conflicts such as in Syria, Yemen, the Sahel region in Africa, and other places around the world. And I think this brings us to question not only the various different issues that are part of the conference themes, but also what does this say about IHL? What is the value and importance of a body of law given its constant disregard throughout the past several years and 2 decades, definitely? Of course, we cannot say that there are no benefits at all to IHL. Clearly, it has led to the placing of some boundaries to harmful conducts, perhaps leading to restraints on Russians' aggressions and actions. There's also a declarative value to IHL, and one should not neglect to mention the importance of the humanitarian access that has been provided to organizations that have reached people in need. But I'm wondering whether these benefits are more valuable than the price that is paid by having a body of law that is not appreciated or has become very ill-suited to address current wars. I can even take this question a step further and wonder whether IHL serves as a veil of the international community, that its mere existence enables acts of oppression under the so-called human rights-oriented international community that has taken very minimal action to intervene and end the atrocities that are occurring in the world. I raise these questions because I'm very concerned of the situation as an individual, of what is happening in Ukraine, and my heart is going out to the people out there and those that fled to other areas of the world, including some that even came here to Israel. As a lawyer, I am also very concerned about the role of the law in these situations of war and conflict. I think we should investigate deeply and clearly why is the law disregarded, why it's so limited in its ability to address what is happening. and to raise questions of its importance or the price that is paid given that there is IHL in the world and it is ignored. As a human rights lawyer that is also an Israeli, worried and troubled after the results of our elections, I raise these questions also in anxiety on what will happen in my region in the future. So I looked at the program, which is fascinating, and I'm sure you're going to have really interesting discussions, and I hope you will have room also for rigorously addressing the issues that I raised, that I hope will come up throughout these 2 days among all the very interesting other topics that are going to be addressed. So with this opening, even though it's not, it raises a lot of issues for discussion for IHL, I welcome you here. I think that this is an extremely important opportunity to raise and discuss thoroughly all the issues that are on the table. I hope that you all have a very interesting and fruitful engagement with each other, and that together as a group you will reach groundbreaking insights on these extremely important issues that you are working on. The Minerva Center for Human Rights is very happy to provide an auspice for such a discussion and sees it as extremely crucial and important. So before thanking all the people involved, I also want to take this opportunity to invite you to follow the Minerva Center for Human Rights activities in our email list. Those of you who are not part of the email list, you can register, and we will be very happy to share with you all our events throughout the year. IHL is only one area that we are working on in regards to human rights. We are working on various other issues within our center. You can also follow us on Facebook and Twitter, and we also hope that you will consider contributing your written work to our world-known law journal, the Israeli Law Review. And as Tomer said, I would really like to take the opportunity and thank Danny, Anat, Michal, Yulia, and Yael Ronen, also from our center, and of course Yuval, who has been constantly involved in this conference. Thanks a lot for organizing this, and I wish you a very engaging and important and thought-provoking and also fun 2 days. Thank you.
Thank you very much. So I'll say a few words on behalf of the organization of this conference, and then we will get the ball rolling. The conference was, as you understand, created 17 years ago with the aim of trying to create a more or less permanent forum for discussion within Israel of IHL issues. There has been a lot of interest in Israel regarding IHL, but we did not have a good structure through which we could actually systematically discuss issues, and the conference was supposed to fill this void and create a safe space, a safe academic space in which both academics but also civil society and government members would be able to come and discuss openly questions relating to IHL, and of course to do this on not only on a national level but also to introduce an international component, and we are very happy and pleased to have been enriched throughout the years by dozens and dozens of top-notch experts, practitioners, academics, sometimes government officials from around the world. So, and that enables us to think about our problems from a more global perspective, but also at times make a modest contribution emanating from our perspective to global issues. And we hope that this conference, although it is not focused on this region this time, would also help us understand better the very difficult situation in that region, but also to some extent would help us also to better understand eventually our own region and our own problems. The conference is, as I said, is an academic space. I mean, we really want to engage in a frank and open discussion. We do not encourage political grandstanding in this forum. We do want people to try to open their minds as much as possible and think and engage seriously in academic issues, both at the level of doctrine, but also on the level of theory and critical theory issues along the lines that Einat had raised. I want to use this opportunity also to thank the Minerva Center for the hard work which was put into organizing this conference. So Dani Evron, the executive director, and Einat Albin, the academic director, put a lot of work. Also with Anat Mishali, who's running the day-to-day operations concerning this conference, assisted by part of the Minerva staff, Yulia, who I saw before, and also a number of students who are helping us. I also want to thank the organizing committee. So other than Dani, Einat, and Tomer Brody, who were in the committee, I also want to acknowledge Professor David Kretschmer, who was on the committee and will chair immediately the first session, and Professor Yael Ronen, who I also saw here before, she's here, and Professor Guy Harpaz, who will join us later today. So that was the organizing committee. We had a difficult choice. We had there was a lot of interest in this conference. We had received many papers from all corners of the world, and we are very pleased to have been able to select what we think is a very excellent batch of papers. Before ceding the floor to Professor Kretschmer to get the first panel, well, the first session with our keynote speaker rolling, I'll just make two housekeeping notes. First, I mean, the proceedings, we do not keep proceedings of this conference, but the conference is recorded. There is a camera here, and that camera is on. The proceedings are recorded, and we normally upload a few weeks after the conference. We load the proceedings. If any of the speakers doesn't feel that he or she wants their comments to be uploaded, let us know, and we will respect your request in this regard. The reason why we record is, of course, is to allow maximum exposure to the ideas and comments which are made in this context. Secondly, we do publish papers from conferences in issues of the Israel Law Review, which fortunately Professor Ronen is here, and she's the executive editor. So we do publish papers, and we will encourage speakers after the conference, if they're interested, to submit papers for publication. Finally, I do want to extend a particularly warm welcome to all guests from overseas, but particularly the guests coming from Ukraine, who've been very generous with their time and at a very difficult moment in the life of Ukraine have agreed to come here and share with us their academic thoughts, but also to some level experiences, and we really appreciate your being here and wish you all the best. Keep safe. So without further ado, Professor Kretschmer.
Good morning to everybody. It is a great honor and a great pleasure to chair the opening session in which this keynote speaker is Professor Marco Sassoli. I could not think of a more appropriate person to open the discussion in this important conference on the war in Ukraine. I'm going to be very brief in the introduction, because I'm sure that there's not one person sitting in this audience who deals with IHL who has not read many of the works published by Professor Sassoli. Marco Sassoli is Professor of International Law at the University of Geneva. He's also a commissioner of the International Commission of Jurists and a member of its executive committee. As you know, he has published extensively in the field of IHL, human rights law, international criminal law, and the sources of international law. People here are obviously aware of the fact that he was editor of the 2015 commentary on the Geneva Conventions, and one of the editors of the ICRC important book about how does law protect in war. His most recent book is the International Humanitarian Law Rules, Controversies and Solutions to Problems Arising in Warfare. We couldn't have a more appropriate title than that for today's conference. Besides being a professor of law, Professor Sassoli has extensive practical experience. He was for a long time in the legal department of the International Committee of the Red Cross and even served as the deputy head of that. He has also been on delegations of the ICRC in various places in the world, including Jordan, Syria, and as protection coordinator for Yugoslavia. From March to April of this year, he was a member of the Commission of Experts under the Moscow mechanism of the OSCE, inquiring into violations of international humanitarian law and human rights in Ukraine between the 24th of February 2022 and the 1st of April 2022. Professor Sassoli has given me the permission to be very brutal in cutting off his talk if he extends the time, because we do want to allow time for discussion. So without more ado, I want to present Professor Sassoli for the keynote address, and his subject will be challenges and opportunities for IHL resulting from the armed conflict in Ukraine. Thank you.
Thank you very much. Shall I speak rather there?
As you prefer.
Well, wonderful. So, good morning. Thank you very much to the Minerva Center to have invited me. And as Professor Kretschmer will be brutal, I take my Swiss watch. And I have to start with some apologies. First, I have a cough, but I do not have, at least on Friday evening, I did not have COVID. Second, I feel very embarrassed that this afternoon already I have to leave you because tomorrow I have to teach in Geneva and to grade some students, and they don't trust my assistants that they are able to grade them, which means third, and I'm really sorry that I cannot listen to you, to your criticism of what I will say, and there will be certainly controversy. And I also apologize that for some of you, I will already speak about your subject. But, you know, you should have invited me to speak about the conflict in Ethiopia. To avoid this, because it would be strange, it rather shows that you chose the right subject. Not on all the subject, and here again I have to apologize that I put an emphasis on those issues where I see legal challenges, while other issues which are as important from a humanitarian point of view, like sexual violence, torture, deportations from occupied territories, which are very serious problems. But I think the law is adequate, and there's the general problem, which is not only in this conflict, that the law is not sufficiently respected. And my final apology goes to all Ukrainians in this room. I know from my ICSE past that victims never appreciate to be compared with other victims, and to have a purely legal, abstract evaluation of the situation. And I fully appreciate that even if IHL was respected, every armed conflict leads to immense suffering, and the victims will not appreciate if you say, okay, but this is somehow, unfortunately, inherent in armed conflicts. And this is why it's so important that we avoid armed conflicts, and international law prohibits armed conflicts. If international law was respected, at least international armed conflicts would never occur. And in my view, but this goes rather into the human rights part, non-international armed conflicts would nearly never occur. Okay, after these apologies, my issues are the challenges, the shortcomings, and the opportunities. I'm nevertheless always optimistic. So I think conceptually the greatest challenge of this conflict, because Russia is clearly the aggressor in this conflict, is what the lawyers call traditionally the separation between jus ad bellum and jus in bello. The importance that even the victim of an aggression has to comply with humanitarian law, and with exactly the same rules of humanitarian law than the aggressor. And this is very important for IHL, because in every armed conflict in the world, both sides claim that they are right and their enemy is wrong. And in most armed conflicts, they really believe it. And therefore, if you accepted differential standards that somehow, if you are a victim of an aggression, you cannot be criticized for small violations of humanitarian law, that would be the end of international humanitarian law. Now, in every armed conflict, I started my ICSE career in the war between Iraq and Iran. And I worked on the Iranian side, and the Iranians told us always, yes, we are fully agree with IHL, and this is in full conformity with the Holy Quran, but we are victims of an aggression by Saddam Hussein, and they were right. Today we can say it was Saddam Hussein who attacked Iran. And believe me, I was not very popular when I said, you know, we don't care that he attacked you. You have to comply with the same rules than he. So everywhere, the victims of an aggression don't appreciate if you treat them as the aggressor. And what is perhaps specific and dangerous in the conflict in Ukraine is that this feeling exists also in the public opinion, in Europe and North America, and among governments. And I personally felt this when in the Swiss radio during the siege of Mariupol, I said that under IHL, as long as Ukrainians defend every house in Mariupol, Russian forces may attack every house in Mariupol. There was a shitstorm in social media. And since then, and perhaps we all should be more careful when we speak about IHL, I formulate it in a different way. I say, as long as Ukrainian forces defend every house, it is not prohibited by IHL to attack every house. While obviously every act, even lawful under IHL, is unlawful if it is committed by the aggressor. So this is clear. Now, one of the consequences of this non-separation or blurring between jus ad bellum and jus in bello is that it is very difficult to criticize violations committed by Ukraine. In our report for the OSCE, we made clear that the Russians' violations are more serious and more widespread. But there are also Ukrainian violations. And I must say that if a government says that it fights to defend the Western values, I'm astonished that this government does not give the ICSE access to all prisoners of war and does not allow the ICSE to be present when there are the so-called exchanges of prisoners of war to check whether these prisoners, and among Russian prisoners you may imagine that some of them would not like to go back because perhaps they are perceived as traitors because they surrendered to Ukrainian forces. Another thing is that the neutrality of humanitarian action, the necessary neutrality of humanitarian action, is profoundly challenged by this environment. You may remember in the month of March that the ICSC president, then ICSC president, Peter Maurer, went to Moscow to discuss with Minister Lavrov, and he smiles with everyone. He even smiles with me when he meets me, so he smiled with Lavrov. And there was a shitstorm in the social media against this. While I must say, when I worked with the ICSC, I was proud that most of the people I negotiated with were presumptive war criminals. Because these are the people who have an impact on what happens on the ground. And in humanitarian action, you want to speak with the people who can change the conduct on the ground, not with the nice lady in the foreign ministry who is not a war criminal because she has no impact. And so I want to speak with those who have an impact. And the same thing is obviously true with the very sharp reaction in the international community which hindered the ICSC to open an office in Rostov-on-the-Don to assist the people which Russia claims are refugees from Ukraine, while there are very important reasons to believe that they were forcibly deported to Ukraine. But if you want to check that, you can't tell Lavrov, look, we want to check that. You have to say, we want to assist them. And then you will see these people and you will learn what happens and try to protect. Okay. Then there is the impression in this conflict, as in other conflicts, that IHL is always violated. And this is profoundly undermining the willingness to respect international humanitarian law. And at least in my experience, this is wrong. Both in Gaza and in the former Yugoslavia, I always experienced that there is also a lot of respect of humanitarian law. But obviously we don't make a conference about the respect of humanitarian law, and there are no reports about the respect of humanitarian law, but I'm convinced that both parties, and what I see on the news, I see a lot of respect by both parties, obviously not sufficient. And it is true that Russia does not help, because Russia doesn't try to justify their actions, you know. When Israel bombs the Gaza Strip, when Saudi Arabia bombs Yemen, when the US bombs Afghanistan or Iraq, they make a legal argument why this is lawful. And they say, we make an inquiry, while Russia doesn't do that. Normally they give no justification at all. And in the rare cases where they give a justification, they say Ukraine bombed its own towns, which can happen once, but not all the time. And so they undermine the credibility of humanitarian law through this. Then there's a lot of misunderstanding in public opinion and among governments of humanitarian law. For instance, and this is very difficult to clarify, every house destroyed, every civilian house destroyed is seen as an evidence for a violation of humanitarian law, which it is not. We should know what was in this house. Did the Ukrainian forces defend this house? Even if it was not defended, was nearby a military objective. To make the proportionality evaluation, we would need to know the plans of the Russian forces, to know what is the military advantage of this attack compared with the anticipated risks to the civilian population, and what precautionary measures were feasible. Another example of the misunderstanding of IHL was the famous press release of Amnesty International, which provoked a shitstorm again, criticizing the passive precautionary measures taken by Ukraine. At least the United States always said that the defender and the attacker have the same precautionary obligations, while I always insist that a defender has much less precautionary. Defender, this is not the victim of the aggression, but the defender in the military operation, much less precautionary obligations. Also, the shitstorm was not by people like me who considered that perhaps the rules on passive precautions were misunderstood, but the shitstorm was by those who considered, how can you dare to criticize Ukraine, which is a victim of an aggression? And so we come back to my first point. And finally, the challenge is that in the global south, and believe me, I have students from Africa, from Asia, from the Middle East, this conflict is perceived by them as a further evidence for an obsession they have, and it is wrong, but we have to accept that they have that. That humanitarian law is something which protects white people against white people, and that the West uses humanitarian law when it is in their interest, but the West does not care about, say, Ethiopia. Now you will say, okay, Ethiopia. Please, in Ethiopia, according to UN numbers, 3 times more civilians were killed since the beginning of this year than in Ukraine. Now, this is also the merit of the Ukrainian authorities, because they have very good organization of passive precautions with the shelters and the systems after some weeks of evacuations and so on, which do not exist in Ethiopia. And obviously in Ethiopia there was no aggression. So in jus ad bellum it's totally different. But we learn in IHL today that mostly the law of international and non-international armed conflict is the same, and no one cares about Ethiopia, about Yemen, about Syria. So this leads to this perception, which is wrong, but we have to see it, that it is a Western agenda. Now, the shortcomings, I will be very short because several of you will speak about this. Obviously, we don't have an interstate implementation mechanism. Switzerland and the ICSC suggested the mechanism. This was refused or didn't find a consensus at the International Conference of the Red Cross. I mentioned the issue of transparency. This is a shortcoming in the law of conduct of hostilities, that parties do not have an obligation to explain, because it's only Ukraine which could explain whether they defended this house. And it's interesting that in the 2 OSCE missions, we had full access to everyone in Ukraine except the military, because they knew what I would ask them. And they have no obligation to give information. And the Russians, which did not cooperate with these missions, they have no obligation to explain what was the military advantage they were seeking. And here we have to change the law, because otherwise either we remain always silent, or we criticize people based on probabilities and somehow assuming that they have committed violations. Similar shortcomings on the protection, but someone will speak about this, of nuclear power stations. The real problem is not, as Protocol 1 thinks, the attack on the reactor, but the problem is the cutting of electricity supplies, which cut the cooling system, and in particular, the protection of the people who work in the nuclear power station. And just to give a last example, the distinction between war crimes and violations of IHL no chance to explain that to the media. I mean, they think I'm a friend of Putin when I say Russia cannot commit war crimes, only individuals can commit war crimes, and for that you need knowledge and intent. Perhaps Putin is a war criminal, but Russia cannot commit war crimes, and Ukraine cannot commit war crimes, and this is a message which simply doesn't go through. Now we come to the more optimistic part. Opportunities. I must say that at least in the Western discourse about the conflict in Ukraine, we encounter a lot of opportunities to have more humanitarian rules accepted. I'll give you one example. The ICSC has suggested since 3 years to have rules limiting the use of explosive weapons with a wide area effect in densely populated areas. I don't know who opposed, but I know it was the United States, the United Kingdom, Canada, Australia, who didn't want that. Then, when Russia used artillery in Ukraine, they all criticized, in my view, rightly so, what Russia did. Explosive weapons with a wide area effect in densely populated areas. And I think the fact that on the 18th of November in Ireland, there will be a conference where states can undertake a legally non-binding. Sorry for that. As a lawyer, I like the legally binding, but no one wanted to have legally binding rules. They are only legally binding on Russia, apparently. They will sign these political commitment, which is a progress, and perhaps this progress wouldn't have been possible without these rhetorics. Or the NATO Secretary General, I didn't believe it when I heard that he said Russia uses, it sounded like an Amnesty International press release. It was the Secretary General. Russia uses unlawful weapons or banned weapons, internationally banned weapons like cluster munitions. Well, neither Russia nor Ukraine are party to the Oslo Convention. And until recently, the United States, and by the way, Israel, if I'm well informed, insists that it is lawful to use, obviously while respecting the other rules, but it's not an internationally banned weapon. I am optimistic that next time someone else uses cluster munitions, they will have some difficulties to justify this after everyone said what a scandal. Then a very positive development is the great international concern with violations of international humanitarian law in that international armed conflict. You remember that until recently, major states like the United States denied the interpretation by the ICSC that it is an obligation to ensure respect for IHL. Well, now they are all engaged in ensuring respect. Obviously, whether they feel obliged is another issue. And also, it is not easy to distinguish the sanctions which are due to the violation of the jus ad bellum, the aggression against Ukraine, and the sanctions which are based on the violations committed by Russia. Nevertheless, I have the impression that every time there is information about major massacres, the US, Canada, European states add sanctions. And I think the most positive thing is nevertheless the fight against impunity. It is absolutely unprecedented that during an armed conflict, tens of thousands of prosecutions, or at least criminal inquiries, were started. The General Prosecutor of Ukraine started tens of thousands of inquiries. And this has never happened. Before it was after a conflict, and okay, in Israel, 5 or something. Sorry, you will correct me, but something like that. But there were some. Okay. Okay, in the beginning, and we criticized that in our report, these were all against enemies, which is correct in IHL, including against prisoners of war. It's correct. It's an obligation to prosecute war crimes committed by prisoners of war. But recently, the Ukrainian general prosecutor has also started inquiries against Ukrainians, and I think this is very important for the credibility of IHL. And Western states cooperated and applied the universal jurisdiction principles in an unprecedented way. Even the Swiss general prosecutor has started a task force on Ukraine. And 2 weeks ago, together with some NGOs, I went to see him because I studied with him. And he assured us that, yes, we said a task force on Ukraine, but you can be assured that we will do the same on Syria, Ethiopia, and so on. We don't need a task force, but we will prosecute them in the same way. And finally, the International Criminal Court, unprecedented. I mean, for Georgia, it took 14 years until the first suspects were indicted. Now, obviously in Ukraine there are no suspects for the time being indicted, but I cannot criticize that this cannot happen so quickly. But the prosecutor reacted immediately, sending teams on the ground and showing a willingness to go forward, which we hope he will also show in other contexts. And I'm confident, and I will close with this, that, you know, I'm half Italian. In Italian courtrooms, before Berlusconi abolished it, every courtroom was written La legge uguale per tutti. The law is the same for all. And this is a profound value of the rule of law and for the credibility of the law. And I'm really confident that this has a great power on the future, that just as we started with the former Yugoslavia, and ICTY, but this would be another colloquium, but which is a little about legal history, made some interpretations which were very revolutionary at the time, but in the meantime, they're accepted by everyone. And so I'm confident that because of the power of the president, a lot of interpretations which are now adopted by European and North American states will become generally accepted and will therefore protect war victims everywhere in the world. Obviously, IHL is never the solution, but I don't have to recall you that armed conflict should be avoided. And every armed conflict, even if IHL is respected, will lead to incredible human suffering. So IHL can never be the ideal thing. It can only be a necessarily insufficient minimum of humanity in a profoundly inhumane situation. But I think, with some exceptions I mentioned, that if IHL was respected more generally in the international armed conflict in Ukraine, there would be much less human suffering. Thank you very much.
Thank you very much, Professor Sassoli, and thank you for avoiding the possibility that I would have had to be brutal.
Yeah.
So it would not be appropriate for a conference on IHL. So thank you very much. And I want to thank you first and foremost for at least introducing an element of optimism, that out of this conference there may be some positive results as far as the development of IHL. I think most people who've looked at the Ukraine conflict at the moment come out only with a pessimistic view. So it's refreshing to hear a point of view which says, well, in the end, there may be some positive developments despite the immense suffering. I'm going to make just a few short remarks because I want to open it for the discussion of the floor. And the first remark relates to the distinction between jus ad bellum and jus in bello, which is accepted by all international lawyers. And it is most clear in the present context that the legal approach is not accepted by the general public. They find it very, very difficult to accept that we should apply the same norms to the aggressor and to the victim, or to the strong party, and the party which is perceived as a weaker party. It seems to me this is a general problem. It's not confined to the present conflict in the Ukraine. It is more obvious in this conflict because Russia is the clear aggressor. It's naked aggression. And so everybody, I would say, at least in the West, except for a few people who are still tied to some kind of communist views, but most people in the West accept totally that the aggression is the aggression of Russia. And that is certainly the perception not only among lawyers, but among the general public. And so it becomes very, very difficult for them when we say, yes, but the Ukrainians also may be liable for violations of the law of armed conflict, and possibly that some of the members of the armed forces may have committed war crimes. I think that that's same as the possibility of people being suspicious about the neutrality of the ICRC, thinking they should take a side, seeing that Russia is the aggressor. What I think that we do need as lawyers, I would say, more public relations in trying to explain why we are so adamant that even in a war in which there's a clear aggressor, the victim party must comply with the same rules of jus in bello with which the aggressor has to apply. Now, you mentioned the perception of some of your students from Africa, and their perception is in the global South that the people in the West have a double standard. And I must say that I don't believe that this perception is totally removed from reality. Because whereas the same legal rules will apply, and we're going to apply the same legal rules, when we do see the attention played by the Western countries and the Western media to what is happening in Ukraine and compare it to what is being devoted to Ethiopia and Eritrea, and what was devoted still at the present time to Syria, there is a tremendous disparity. And so I cannot deny that the perception of people, especially from the African countries, that somehow there's much more attention of the international community when it's European countries fighting European countries. I don't think that it's far removed from reality. Now, a question that I do want to pose here. We had a previous conference of the Minerva Center on the connection between human rights and IHL. And as we know, the accepted view today is that even in armed conflicts, human rights continue to apply, since the advisory opinion of the International Court in the nuclear weapons case, this has been the accepted view. Not all accepted by all countries. I think that Israel does not accept it, the United States does not accept it, but it is the generally accepted view. And the question that I want to ask is, has this not contributed to the notion that we have to have equal application of IHL to both parties in the conflict? Because when you see it as a human rights issue, then it sometimes takes on a different aspect. And that is the whole problem with IHL, that we are saying, well, we are dealing with a reality. It's a reality which we think should be outlawed. It is a reality which is outlawed, but we have to deal with what actually happens. And when it actually happens, we're going to apply the same rules, which, as I said, is counterintuitive. Now, there's one question, Marco, that I would like to ask you. And that is your view that if a house is defended by the military, then it becomes a legitimate target. Now, the military may be a legitimate target, but do I understand you to say that if the house is a civilian object, but the Russians obviously are not paying much attention to the distinction between civilian objects and military objects, and it happens that military people are defending that civilian object, does the object then become a legitimate military object? I would think that it does not, although they may be able to attack the soldiers. They are legitimate targets, but attacking the house itself, I think in my mind, is a bit problematical, so I would appreciate it if you would clarify that. Now, of course, the main issue here, and that is the one pointed out by Enat, and it's clearly obvious, it's more or less self-evident, in that in the Ukrainian situation we have this huge enforcement deficiency. As Marco pointed out, we have no institutional arrangements for the enforcement of state liability for violations of jus in bello. We have criminal liability, but the criminal liability is not proved adequate in trying to deal with state behavior, especially when we are talking about practices and policies and not individual deviations from legal standards. It seems clear that Russia does not regard itself as bound by most of the rules of IHL. And as Marco pointed out quite correctly, it doesn't even try to make the legal argument of why its actions are justified. It did try to make the legal argument on spurious grounds why its attack on the Ukraine was justified, but no lawyer would accept those grounds. But at least it made the attempt. It is not doing it in IHL, which leads me to an interesting point connected with the Israeli situation. Yael Ronen and I wrote a book about the judicial review of the Supreme Court of Israel over actions of the military in occupied territory. But one of the chapters in the book, we dealt with judicial review during hostilities, over the actions of the military in hostilities. And what did we find there? That what the court did was to force the authorities to give them an accounting, to try to tell them why what you are doing is compatible with IHL. The court was not about to intervene. It said the scope of judicial review is highly limited. But given what you say, I now am beginning to revise my view on this, that I think there was importance to the mere fact that the court said, what you're doing, you have to justify on legal grounds, and you have to provide me with the legal justification, which has, to a large extent, importance. Now, as far as the opportunities go, well, I would like to share your optimism that the attitudes taken by the Western countries in this conflict would have some kind of effect on their future attitude towards treaties, especially when it comes to cluster weapons. I am not sure politically if this is going to happen. I think that countries are very good at adopting double standards and trying to justify why it was necessary in one situation but not in the other. It's rules that apply to the other guys that don't necessarily apply to me, but I would like to share your optimism and hope that I will be wrong on that. So I'm going to end there, and I would like to open the floor for questions or comments. Well, silence means consent. Marco was very worried. He said he's going to be attacked. Yes, please, could you just say your name?
Yes, hi. Anna Makitenko, Global Rights Compliance Senior Legal Advisor. At the risk of sounding defensive, being a Ukrainian and being a part of the shit show that you mentioned in response to the Amnesty International piece, I co-authored with Wayne Jordash a piece called What's Wrong with Amnesty International's Conclusions on Ukraine. This is not a shortcoming of IHL, with all due respect. This is a major failure on the side of Amnesty International and many other actors that you mentioned in your speech to apply IHL. And therefore, it's not about the neutrality of IHL or neutrality of humanitarian actors. It's about how these actors apply IHL. And
no,
if
I said misunderstanding.
Not misunderstanding, Amnesty failed to analyze the situation that it reported on. It did list the facts, but it didn't list the methodology. It did not care to receive comments of the Ukrainian military, giving it only 3 days to reply to the written questions. And of course, it did not actually argue in its piece whether or not there was military necessity to attack civilian objects, whether or not Ukrainian side indeed did or did not take precautionary measures, and so on and so on. Anyway, I won't go into details of and will not explain that piece all over again, but my point is that it's not in itself a shortcoming of IHL, and it's actually another reason to be optimistic that if IHL was properly applied here in the arguing of the report, and if Amnesty actually considered all the relevant IHL rules, it could have been just another example of how IHL regulates the situation in Ukraine. So it's as much about the rules in itself as it is about how the rules are being analyzed and applied to a specific situation. Sorry again, I know this sounds very defensive.
No, you know, perhaps I should have had a PowerPoint. This was not under shortcomings of IHL. I agree with you that IHL, at least as I interpret it, and apparently you too, foresees much lower obligations of the defender than of the attacker, which had nothing to do with the aggressor and the victim of aggression. But this is not the position of the United States, which say equal obligations. And sometimes I heard this also from Israel, but only in theory. Now, but I didn't mention it under shortcomings. I mentioned it under misunderstandings of IHL. So the two of us, we agree. And then there are the procedural issues, which comes back to my transparency point. You know, the problem for an NGO, but also for a mission of inquiry like the one I participated in, we should, on conduct of hostilities, not on rape, torture, forced displacement. On conduct of hostilities, we should always be silent because we don't have all the information. So we should, and I agree with you, we should get information from the parties. Now the parties don't have an obligation to give information, but I agree with you that 3 days is too little. I wonder whether, and I hope, Ukraine, to us they didn't give, the military. Everyone else gave plenty of information. And the Russians didn't give any information, but I had a former student who gave me information from Moscow. So that's the privilege of a professor, that he has his secret services. Okay, but I mean, indeed, on this feasibility, you describe it exactly correctly, that on the feasibility issues, only the Ukrainians can say whether it was feasible, which, you know, I was a simple soldier in the Swiss army, and we never made war, so I'm not an expert. But even I find it slightly naive, but all UN Human Rights Council missions of inquiry have a similar methodology to simply say, well, I mean, we are not convinced. They could have put it in the woods. In the midst of the woods, the defensive positions. But I mean, this is also for the feasibility of active precautions for the attacker. It's also an issue which often concerned in the past Israel, that somehow to say, we are not convinced that you took all active precautions. Well, you have to show us which precautions were feasible. And this implies the necessity of a dialogue with the state concerned. And as I said, there's no obligation in IHL to have a dialogue. And therefore, everyone, including the mission to which I belonged, makes suppositions. And for the prosecution of war crimes, this is even more difficult, because obviously you cannot sentence someone because of a probability evaluation, but you have to prove. And how can you prove when only the other party, when only a party which has no obligation to cooperate has the necessary information? So basically, I agree with you.
My question is, I think, another pushback on your assumption that protecting a civilian object might turn it into a military object. And then I'm asking, what are we thinking about Iron Dome? So if we put Iron Dome before civilian towns, does that mean the entire town to be a military objective to your kind of analysis? How does that work? Where's the limitation to it? And where do you stand?
Well, thank you very much to ask this question, because I wanted to react, but then I thought, well, we want to have a discussion with the public, not between the two of us. We can have that afterwards. But I'm sorry that my answer is quite sophisticated. I would make a distinction between the situation where the military are simply present in a civilian house. Then the military remain a legitimate target, but the civilian house does not become a legitimate target by use, because they don't use it to commit hostilities. Why? If they are in a house to wait for the enemy until the enemy comes near the house, and then they shoot on the house, they use the house for military purposes, to shelter themselves not from the rain or the cold, but from the enemy. And this, in my view, makes the house a military objective. Obviously, then you still have to apply the proportionality rule and the precautions. But I would say it becomes a military objective, and then obviously what becomes quite sophisticated, and if you want to read about that, Noam Lubel, who is here, has written on that. Is it just the apartment where the military are, or is it the whole house? If you have obviously sufficiently sophisticated weapons. That's a complicated issue, but I think indeed I agree with both of you that the simple fact that military are present in a house does not make the house a military objective, but if they use it to commit hostilities, it becomes a military objective.
Thank you.
Which is, by the way, not unlawful, because human shields, please remember, it's unlawful to use civilians, while it's obviously not unlawful to use civilian objects to shelter. I mean, even in the Swiss Army, we put always our tanks under trees, and camouflage is by definition making the enemy believe that this is a civilian object, while it's not a civilian object, it's a Swiss tank.
Thank you. Noam Lubel?
Just want to maybe this issue of the houses, raise it from a slightly different perspective that I think does point to potentially I'm not sure if it's a fault necessarily with IHL, but it is a dilemma, and it came up in a conference I was speaking at on Ukraine conflict recently, and that is essentially, and it goes also to the ad bellum in bellum divide. When you have a situation where one side is unlawfully attacking a civilian area. The other side then, in response, wants to defend the area. By the very act of defending from within the area, because that's where you need to defend it from, you can't really defend it from the woods, you then turn the area in one way or another into a legitimate target, even if it's just the forces that are being targeted and not the buildings. And so you've got essentially this sort of cycle that starts out with an unlawful act, which almost in a way turns the unlawful act into a lawful one. Because initially it was unlawful to attack the civilian area, but now the defending troops are there, you can attack them. And suddenly all of those attacks get legitimized. And I'm not quite sure what the way out is here, but it's, I think this conflict has provided us with a real example of this problem.
I agree with you that this is a dilemma. This is the general dilemma that we should avoid to presume that the party anyway doesn't care about IHL, because otherwise IHL doesn't work. Because, I mean, if you assume that the enemy anyway wants to target civilians, then all the rules of IHL are meaningless. Somehow this is genocide, and we shouldn't so too easily assume that. And the whole discussion about the Amnesty International report shows also that apparently, because otherwise it's meaningless, the report. If it is true, which I don't believe, not because I like Putin, but because I never experienced an armed conflict where one party always violated IHL and another party always respected IHL. This never happened. But if we believe that Russia anyway wants to target only civilians, which would be militarily very stupid with a powerful army like the Ukrainian, if I were the military, I would target the military, but okay. Then somehow there's no sense of saying, was it feasible to put them elsewhere or anyway? If they want to attack civilians, why would they put at risk, and this is the underlying assumption of the whole thing about feasible precautions by the defender, why would they put the civilian population at risk if they put a military base there? And the same thing is true with hospitals. I mean, the assumption why you may not use hospitals to launch attacks, and why the hospital only loses protection if it is used to commit hostile acts and a warning and a time limit, all this works only if you assume that the enemy doesn't want to attack the wounded. Because if the enemy wants to attack the wounded, this is totally useless, these rules. And you know, we have experienced that in Bosnia. Sorry to tell you, the discourse about the Serbs in Bosnia was even more Manichaean than the one about the Russians in Ukraine. And I always said, yes, but you have to, I mean, then IHL have no more sense. If you really assume that, which was an argument, that the aim of the Serbs is to get rid of the Bosniaks, then somehow the principle of distinction is meaningless, because by hypothesis, they didn't even want to kill Bosnian soldiers. Well, I think the Russians want to kill Ukrainian soldiers because they would like to win, and they don't succeed. So it is rather, maybe again, optimistic. Perhaps this campaign by Russia against Ukraine has shown that you better respect IHL because you are less efficient if you with indiscriminate attack. I mean, with all the munitions they have, if they concentrated these munitions actually on the military, perhaps they would be in a better position than they are now. But I don't say I wish that they were in a better position, but at least the civilians would have suffered less.
Thank you. We're running out of time. We started a quarter of an hour late, so I allowed myself to take an extra quarter of an hour, but we can take one more comment, Professor Korn.
Yes, so two comments. I'm struggling a little bit with your characterization of the U.S. view on precautions applicable to each side. I think that the U.S. view is that the obligation is equal, but the implementation is certainly not expected to be equal. I mean, even the way Article 58 precautions are defined is much more variable than the 57 precautions. So I don't think the United States takes a view that there's an expectation of equality in implementation. I do want to suggest, or maybe ask you, if there's another area of optimism, and that is the ever-increasing relationship between the perception of respect for IHL and strategic legitimacy being such a critical aspect of military operations. And for me, that's one of the really significant lessons that can be drawn from this most recent conflict. I think the Ukrainians generally recognized before the conflict began that creating the perception of strategic legitimacy was something that was going to be an advantage for them in the international community. And to do that, they have to create a perception and reality of respect for IHL. And I think they're facing an enemy that doesn't share that perception. And the consequence of that is profound. So to me, when we think about IHL and its efficacy, obviously you need national and military leadership that embraces the logic of implementing it. And this, to me, is one of the really interesting evolutions of international humanitarian law as it intersects with strategic policy. The recognition that the actual and perceived respect for the law is a net gain, not just at the operational level, but also at the strategic level. And I see that playing out. I'm curious if you think that's a source of optimism as well.
Well, first, on the first point, I was superficial, and I agree with you. I'm too influenced by what I read from Hayes Parks, who is very extreme on this point. But the official U.S. position, I think you described it correctly. Same obligation, but you know, the attacker also is subject to feasibility. And at least I have published an article claiming that the concept of feasibility is the same for the attacker and for the defender. But okay. Now, on your strategic point, this is an old argument in favor of respecting IHL, that you will win a war if you keep the, especially if you're the weaker party, if you comply with the IHL and so on. Now, so I basically agree with you, but simply because we are in a discussion, I have to mention to you the limits of this argument, which is also linked to the separation between jus ad bellum and jus in bello. Now imagine you had been the advisor of Putin, and Putin listened to you. And Putin would have said, I want to get Ukraine. But, Jeff, how can I get strategic legitimacy? And you would have said, you have to comply perfectly with the IHL. And please accept, you can comply with the IHL and take Ukraine. This is our supposition. Otherwise, we close the shop of IHL. And then imagine the strategic legitimacy of the aggressor. And there I'm not so sure that if you are an aggressor, you would get strategic legitimacy by complying with IHL. But some more. Yes.
Okay. I'm afraid we're going to have to end the interesting discussion there. Well, I want to thank Professor Sassoli very much. I could not think of a more appropriate opening to our conference. I think the issues that he raised are going to be the issues that we're going to be dealing with over the next 2 days. So join me in thanking our guest speaker.